are you?
Hanging in there. It's raining.
Yeah, it's cold in the Twin Cities.
I want to say it's cold.
I thought I saw a snowflake about an hour ago.
I wouldn't doubt it.
I'm gonna get my tinsel and lights back out.
Okay. Attorney Anderson, are you connected? I think he's working at it. So Attorney Gaudino, did you see the snowflake that Attorney Adams was talking about?
I don't live as north as him, so I hope not. I hope he's seeing things.
I'm closer to Lake Superior than he is.
Oh, okay. Well, I'm in St. Croix today, so I don't know what the temperature's like up there. But it's definitely warmer down here than it is up there.
Okay.
There he is. Attorney Anderson, how are you doing today?
Good morning, Your Honor.
Good. I hear you just fine. I'm assuming you can hear me all right?
Yes,
Good. Attorney Adams was throwing some harsh shorts around today. You mentioned snow. I was hoping we were beyond that by now. Well, it's really encouraging down here in St. Croix is that I'm seeing lilacs. So that's encouraging for me. Okay, are we prepared to begin?
I believe so.
Tribe is, Your Honor.
Okay. Read the case.
Case today is in the interest of the St. Croix Chippewa Indians of Wisconsin versus K.Johnson. Case number 21-CB-200. Presiding today is the Honorable Judge Stephen Woolley. The appearances for the record, Your Honor, are for the tribe, Andrew Adams III, Ashley Duffy, and Lorenzo Godino. And then we have the defendant, K.Johnson, with her attorney, Bruce Anderson.
Okay, good morning, everyone. Personnel
Morning, Your
session. Where we left off the other day, the tribe had just completed presenting their case. And it seemed like a good time to take a break, and Attorney Anderson had indicated that he's ready to call his witness and would start today with that. Last when we talked about the witnesses, Attorney Anderson indicated that you're only going to have one witness. Is that still the case?
It is.
Okay. So we'll go until about say 10:15, 10:30. We'll take a break at that time. We'll take a lunch break around noon, and then we'll see where we are at that time. See where we're going to go. But if I recall right, my notes indicate that today we could only go until 3 o'clock. Is that accurate? I think someone had a commitment at 3 o'clock, so we could only go.
Yeah. Yes, Your Honor. I believe we previously agreed to wrap things up at 3 o'clock today.
All right. If we're still going at 3 o'clock today, we'll sit down before we adjourn. We'll discuss what we need to do next. But we still have time on the docket for I think it's next Wednesday and Thursday or something like that. So if we need those days are still there. Okay, with all that, Attorney Anderson, your case.
Thank you. At this time, Your Honor, I don't know if the court would like to swear Ms. Johnson in again. There's been several witnesses and it's a new day.
Yeah, let's do that. Let's have Ms. Johnson sworn in.
Raise your right hand.
Do you solemnly swear that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Please state your name.
Karen D. Johnson.
Ms. Johnson, when did you last work for the St. Croix tribe?
I was let go July 2019.
Up until that time, well, what was your job title at the time you were discharged?
Housing specialist.
Were you ever a program accountant?
No.
Ms. Johnson, you were shown dozens and dozens of vouchers where your name signature appeared on the program accountant line. Do you recall that?
Yes.
What was the process within the housing authority up until the time of your discharge from 2014 forward as to how vouchers were presented to Dwayne Emery, the director?
He would look over the bills. I would voucher them up. And then either I would set a time that he would sign them, or I would, if he came in, I would try to get him to sign them, but he would either sign a couple and leave, or he wouldn't sign any of them.
And I'm gonna have to ask you to speak up a little bit, Ms. Johnson. The vouchers that you had prepared for Mr. Emery, did you hand them to him, place them on his desk? What did you do with them?
Usually he would come into my office and I would set them on, we had a table in there, and I would set them on there, and he would, usually he would look at them, but like I said, he would sign maybe a couple, and then he would get up and leave and wouldn't sign the rest of them. Or
were all of the vouchers that were shown to you by Mr. Adams, were all of them made available to Mr. Emery by you?
yes,
Now, I want to turn to the broad category of what the tribe has called unauthorized overtime. And the allegation is that there were $9,853.36 of unauthorized overtime. Do you recall that?
well, through this, yeah,
Okay, now, first of all, Karen, did you work the hours for which you got paid with Housing Authority funds.
Yes,
Were you on an open schedule such that you would work whenever necessary?
Objection, leading question.
Actually, it calls for a yes or no answer. Doesn't suggest the answer.
Can you restate the question, please?
I certainly can. Ms. Johnson, how is it that you came to work overtime from June 12 of 2014 through through June 21 of 2018?
whenever I was called in by Dwayne, that pertained to whether it was weekends, holidays, even when I took vacation, I would have to go in.
Okay, now the checks you were given for overtime don't appear to have gone through a payroll office. Would you agree?
Agree.
And how did you keep track of the overtime that you had put in?
On timesheets.
And where were those timesheets kept?
They were kept, I believe I made copies, or someone had made copies of them through the tribe. So we actually got them from the tribal, or from the tribal center.
Did you perform work for all of the hours that you were paid overtime?
Yes,
According to the tribe's criminal complaint, there appear to be 15 occasions over 4 years. Is that the overtime you worked?
I would say there was more than that.
If you didn't get paid, is that because you didn't document it?
Yeah,
Now I want to strike that. Now, were the amounts of overtime written up as a voucher?
yes.
Can you tell me how many hours a week on just an average Dwayne was in the office?
A week?
Yeah.
Oh. Maybe 4.
And is that the time frame you had to get him to sign vouchers and review bills?
Yes, but usually when he was there, he would be there early because he would usually unlock the door. So when I got there by 7:30, 8 o'clock, he was already gone.
Were the vouchers moved for the most part from as if they had been reviewed by him?
Objection, leading.
Sustained.
I'll
Rephrase the question.
when you came in, what did you find as far as the vouchers? Were they?
If I had left him on the table,
Objection, objection, calls for speculation. This is not There's been no foundation about speculating as to what she would find.
All she's gonna testify to is what she found. That's not speculation.
Just on general principle, or when it comes to specific checks and vouchers?
What she found on any occasion.
I call that speculation.
I don't know how you can call it speculation when it's something she found.
So
She phrased the
she's
question. Let's move along.
Were the vouchers in the same place as where you had left them when you left the night before?
Yes, but my office was always locked, and when I would get there, it was always unlocked, so he had every chance to look at them.
You don't know if you looked at all of them.
No,
I now want to move on to what the tribe's complaint has labeled personal expenses of $6,359.69. Tell the court why you purchased a Go Oahu card.
I had gone over there for training, and Dwayne had okayed us to have like just a pass or whatever, so we could do extra activities over there when we were over there.
Do you remember realizing it was back in March of 2016? Do you specifically recall going to Hawaii for a training seminar?
Yes,
Was that housing related?
yes,
You testified that Dwayne authorized this for you, correct?
correct.
Turning to a $158.25 iPhone 6 repair by Staupe, Staupe Computers. What did that relate to?
I believe I broke my phone.
Okay, is this a phone you used for work purposes?
Yes,
Was it a tribally owned phone?
no,
Did Housing Authority give you a phone?
no,
Did Dwayne ever give you a phone?
no.
If you can, Ms. Johnson, what was the hierarchy, if you will, within the Housing Authority? Was Dwayne in charge?
Yes,
And who was directly below Dwayne?
no one.
Okay. Who did you report to?
Dwayne.
You've had reference earlier to a Natasha. Who did Natasha report to?
Dwayne.
She didn't report, or did she report to you?
No.
The next item on the personal expenses is hockey tickets for a Blackhawks versus Wild hockey game to be played February 8th of 2017. Do you recall going to that hockey game?
Yes.
Was that hockey game in any way tied into, again, on February 8th, was it tied into any training that was work-related?
No.
Did Dwayne authorize you to purchase those hockey tickets?
Yes.
Let me ask this. Did you go to Dwayne and ask if you could purchase those tickets?
Those I don't remember. I know at one time he had mentioned that I should take my kids to hockey because my daughter obviously was in hockey and loved hockey. So I'm not sure if he mentioned to take her to that.
But it was an earlier discussion.
Yes.
Objection, hearsay.
The acceptance of the
That was hearsay.
here. Pardon me?
The objections sustained, that was hearsay.
I would like to be heard, just to make a record. Mr. Dwayne Emery was an employee of the plaintiff, and that would be an admission of a party opponent under a respondeat.
Objection, objection. No, they've got to produce the witness to corroborate that statement. That is hearsay.
Counsel, I was arguing my objection. You can have I'm sure the judge will allow you to state your piece afterwards, but I was in the middle of my argument. It was not anything you can object to. I have never seen an attorney object while another attorney is speaking their reasons for why they want to make a record and why it should not be considered hearsay.
Attorney Anderson,
Yes, Judge.
continue with your statement.
Thank you. Ms. Johnson has testified that Dwayne was her superior in the housing authority. That's been throughout this entire proceeding. Under the theory of respondeat superior, the statements of Mr. Emery, who at the time was a supervisory employee for the plaintiff, are statements or admissions of a party opponent, and therefore a direct exception to the hearsay rule.
Attorney Adams,
Your Honor, I could be totally mistaken, but Ms. Johnson about 5 minutes ago testified that no one was below Dwayne. She just testified to that. So how can the defendant proffer a theory to the court now that that respondent superior applies and that it was an admission of a party opponent? That, Your Honor, that dog doesn't hunt. She just testified that no one was below Dwayne. So unless she's ready to contradict her testimony or provide some other evidence showing that, every statement she makes related to a conversation with Dwayne Emery is hearsay unless she is prepared to provide Mr. Emery's verbal testimony on the record. And to also say that it's respondent superior and it's a admission of a party opponent, he is essentially blaming the victim. He is blaming the tribe in terms of saying that because Mr. Emery was the housing director, that he was automatically and he still remains to be a party opponent. I don't understand that logic, Your Honor.
Attorney Anderson,
Any statements that we intend to provide relate to the comment by Ms. Johnson, her testimony earlier. She stated that she reported to Dwayne Emery and that he was the director of the housing authority. Any statements that we intend to offer were statements made by him while he was in fact the housing director. The argument, it reminds me of some of the he said, she said cases where employers have been found liable for acts of their corporate officers towards subordinate employees, where the subordinate employee has said what the particular supervisor may have said or done, giving rise to their claim. It's just not hearsay.
Your Honor, if I may.
hold on. Okay, Attorney Adams.
Your Honor, Ms. Johnson has made contradictory statements on the record concerning the hierarchy in the housing authority. And Your Honor, through the course of these 5 days, she has not produced, they have not proffered, not only over the course of the 5 days, Your Honor, but through discovery, we didn't receive one document. We didn't receive, we haven't received, they have not declared a witness that can corroborate anything that Ms. Johnson is saying. And because of her own contradictory statements on the record, I believe that the court has to seriously consider her credibility when she says that no one was under Dwayne, but in the next sentence, she will say that she reported to him. And then she will say that $1,000 worth of hockey tickets or whatever else the expense was approved by Dwayne, but there's no proof of that. And they haven't presented Mr. Emery to the court to corroborate what she is saying.
Attorney Anderson. It
Well,
appears to
Your
me,
Honor,
it appears to me that you're trying to get statements of Mr. Emery into the record without producing him as a witness. That's troubling to me. And it's causing me to considering to strike any reference you make to Mr. Emery, but I'm also going to respect your client's ability to present her case. So what I'm going to do is this. As far as her actions or what she did in the performance of her duties, and as her explanation to the events that have occurred that have brought us in the court, she can explain why she did them. But if she's going to get around to making statements about what Mr. Emery has said or didn't say, I'm going to want that stricken. So as far as that explanation goes, when you reference Mr. Emery, cannot be any kind of reference to any phrase that he may or may not have said. You may continue.
All right, turning your attention to Ms. Johnson, maybe we should try to clarify, again, the hierarchy within the housing authority. Were you on a equal authority basis with Dwayne Emery?
No,
Was he your boss?
yes,
Did you have any authority over Natasha?
no,
Were there any housing specialists at the time of your discharge besides you and Natasha?
there was, yeah, Jody. I don't remember her last name.
Okay. When you said that there was no one under Dwayne Emery, can you explain that?
Well, he was the boss. There was no one else to go to besides him. I mean, there was no one next in charge, I guess.
Thank you. In the hopes of moving along here, the next item is tickets for a Brewers at Cubs game on May 20th, 2017. Did that take place in Chicago?
Yes,
Were you on any kind of a housing authority trip?
I don't remember if I was or not.
So it's possible you went to Chicago without being on housing authority business?
Possibly.
How about for 4 tickets for a game on July 24 of 2017 for a White Sox at Cubs game? Do you recall, were you on a housing authority trip?
I possibly could have been.
You can't be sure.
No,
Next was two tickets for Brewers at Cubs game on July 6th, which was a rescheduling of the Brewers at Cubs that was supposed to take place on May 20th. Did you buy 2 more tickets? If you recall.
I don't recall.
Do you recall purchase of 2 Chicago Explorer cards to go to various tourist locations in Chicago?
Yes,
Were you on a housing authority business at that time?
that one I'm sure I probably was, yes.
All right, now the next 3 all relate to a golf outing. Dunham's, Blaine's Farm and Fleet, and gift cards from the Cumberland Golf Course. Do you recall the golf outing?
Yes,
Where did you play? Where was the outing?
it was, I don't remember the golf course that it was at. It was, I'm sorry, I don't remember.
If your prior testimony was that it was at Black Bear Golf Course,
Yes,
hold on, let me finish my question. Does that ring a bell?
yes.
Where is Black Bear Golf Course?
Up. Is it kind of by Minot, up that way?
Did you go to the golf outing?
Yes.
Who attended? I mean, who was the outing for?
It was for all the employees at the housing authority.
And first of all, do you have any estimate as to the number of employees who attended the golf outing?
I would say maybe 20, 15, 20.
What types of employees, by category, did the housing authority actually have in its employ?
There was the office people, there was the housing inspectors, then there was maintenance people. We had a wood cutting crew at the time. That's probably about it.
Did you have handymen, or was that the maintenance?
Maintenance, yeah, handyman maintenance, yeah.
Was this open to all employees of the housing authority?
Yes, it was.
Was it a perk for them for the work they did for the housing authority?
I would say so, or just more or less like a appreciation for the work that they did.
Excuse me. Now, if a housing authority employee didn't attend the golf outing, would that have been the employee's choice?
Yes.
Next, there is a November 30, 2017 Walmart receipt, which included office answering machine, chips, dresses, sweater, sunglasses, and a hairdryer. Was that a purchase for housing authority purposes?
The food and the answering machine were, but I don't recall getting any of the other stuff.
Who was, is there a person named Tasha?
Yes, Natasha.
Oh, I see. Might some of these items been fur, if you recall?
Objection, calls for speculation.
I'm going to overrule that because the word there is might. Please answer the question.
Yes, it possibly could have been.
You're not 100% sure.
No, I don't recall.
All right, the next or last one then is $1,000 for hockey tickets for a game to be played on February 10 of 2018. Do you know, were you in Minneapolis or St. Paul on housing authority business for that?
I don't recall if I was or not.
Did Mr. Emery object to any of these payments?
No,
I want to cover two things again. As far as what the tribe has labeled unauthorized overtime, were the vouchers for that processed in any different manner than any other vouchers you processed?
no,
Were they put in the same place as other vouchers?
yes,
Was any attempt made to hide any of them?
no,
Turning to the personal expenses, was any attempt to made, again, what the tribe has labeled personal expenses, was any attempt made to hide any of those?
no,
Were they placed in the same place as all other vouchers?
yes,
And where was the ultimate resting place for these vouchers?
like after they were paid.
Yeah.
We had a room with cabinets that we kept all of the checks in. Or all of the vouchers,
That was a room within, was that a room within the housing authority?
yes,
Was it a room that Mr. Emery had access to?
yes.
Was it a locked room?
At the end of, I'd say the last year, it was locked, but other than that, no, it was not up until,
Did you have a key to the room?
yes,
Were the cabinets, the filing cabinets, were they locked?
I don't believe so, no.
All right, I want to turn now to what the tribe has labeled unauthorized mileage and travel of $32,210.17. Did you go to a webinar in Grantsburg on renewable energy?
Possibly, yes, I don't recall, but we did go to renewable energy meetings.
Why would, I mean, this is, webinars, normally I sit in the basement of my office building and watch a webinar. Can you indicate why you may have gone to Grantsburg for a webinar?
I don't recall.
The next one is for December 28 of 2015 for a regional meeting in Duluth for hotel and mileage. Do you recall going to Duluth where the hotel was $105 on a Thursday, Friday? Over New Year's weekend of 2015 to, it's typed up 2015. I'm guessing it should have been 16. Do you recall going to Duluth for a regional meeting at or about that time?
I don't recall.
Okay. Were there regional meetings in Duluth?
Yes, they were all over wherever they wanted to hold them, I guess.
June 28 of 2016, a trip to Target Field, mileage. Was that to a ball game?
Yes, I'm assuming, yes.
And any housing authority purpose?
I don't recall.
Did Mr. Emery object to any of the renewable energy series mileage, regional meeting, hotel and mileage, or the trip to Target Field for mileage?
Objection. Hearsay.
Well, I'm not asking him for anything he said. I'm asking. you-
Sustained. Move along.
You already testified that the mileage for a trip to Stout was for a college visit, is that right?
Yes,
All right, the next one is for a Chicago HUD review. What? Why did you go to Chicago for HUD reviews?
because that's where it was based out of. We had to go see, I don't know what her name was. I
Okay,
forgot.
you said it. What are you referring to?
HUD.
That appears to have taken place right after the 4th of July weekend in 2017.
Yes,
Do you recall going there?
yes, I do recall.
Was that housing authority business?
Yes,
Mrs. Johnson, apparently there were 2 rooms. Did your children go?
yes,
Was that authorized by a supervisor?
yes,
If you know, were the meals charged for $192? Did that include meals for your children?
I don't believe so, no.
According to this, it says you stayed at the Hilton in Chicago. Is that near the HUD headquarters?
Probably within walking distance.
There's a charge next for valet parking, same dates. At Chicago. Was that for your parking while you stayed at the Hilton
Yes,
and went to the HUD review?
yes,
Next one is July 17th for a Chicago review where you apparently stayed a Sunday through Wednesday, July 23rd to July 26th. Do you recall going to Chicago on that? What's labeled Chicago review?
I don't recall. It was-
It would indicate that you stayed at the Embassy Suites, Chicago. Do you recall that?
I don't recall, no.
On August 10th of 2017, you billed for mileage and meals for a Chicago trip. Did you go on housing authority business for that day?
Possibly.
Do you recall doing just a down and back trip for HUD?
Yes.
Did you have to deliver documents or answer questions? What did HUD have you do at these reviews?
Objection, leading.
What did HUD have you redo at these meetings? How is that possibly considered leading?
You just asked her if she said nothing about delivering documents or down and back. You provided that as you're testifying. That's a leading question.
Absolutely not. A leading question suggests the answer, such as you delivered documents to HUD, didn't you? That is a leading question.
Goodness. I think I heard Your Honor, Attorney Anderson suggest to the witness that she delivered paperwork to Chicago. And where I mean, at least from my perspective, that's a leading question. I mean, a non-leading question would have been, Ms. Johnson, why did you travel to Chicago on August 10th? What was the purpose? Instead of suggesting what it was for.
That's the way I heard it too. So that the leading question, rephrase, objection sustained.
Ms. Johnson, there's 2 trips to Chicago. One on August 10 of 2017 and one on August 29 of 2017. Do you recall either of those trips?
Yes.
What did you do? If you recall.
I believe it was to try to talk to whoever our contact person was, but I don't remember their names or her name. I think it was a her.
Was that Housing Authority business?
Yes.
This is going to sound silly. Was there could you have called this? I want to don't get accused. Give me a moment, Judge. I want to frame this. Was this person available to you by telephone?
Yes, and by email, but she would never get back to me.
All right. Next is the Global Gaming Expo. Now, under direct examination by Mr. Adams, you testified that the Global Gaming Expo did not have direct purpose for the housing authority. Is that what happened? What you said?
Yes.
Did your supervisor go to that Global Gaming Expo?
Yes.
Did you attend?
Yes.
Did anyone else from housing attend, if you know?
I believe Natasha probably went.
Okay. All right. Next is another Chicago review. which shows that you went to Chicago on a Saturday. Was that? I mean, was HUD open Saturdays?
No,
You know, do you know what that one was?
no, I don't recall.
I'm going to skip where there's alleged double dipping, but I'm gonna turn to you, acronyms are on here. The one on 10/26/17. You've already testified that it was a Chicago trip. HUD is housing. What does HUD stand for? If you know,
Housing Urban Development,
what does APR stand for?
annual performance report,
And then what does IHP stand for?
Indian Housing Plan.
Is this something that required you to go to Chicago on behalf of the housing authority?
Yes,
Can you tell the court why you may have taken the route to Green Bay and then south through Milwaukee to get to Chicago, if you recall?
I don't recall that.
If there was a more direct route, do you accept that that's what you could have done?
Yes,
All right, then on November 2 of 17. Please tell the court what ICDBG is.
Indian Community Development Block Grant.
Would indicate that you went to Chicago for training.
Yes, I believe we were gonna try to get that grant. Apply for it.
And was that on behalf of the employer?
Yes,
Next on one voucher, you had mileage to Hayward as well as mileage to Chicago. Were those trips, well, one was on the 17th of November to Hayward. Any idea what that was for?
I know the office people went up there for a meeting and it was to hear someone speak, but I don't remember who it was. That might have been that day.
And you show mileage to Chicago. Do you recall going to Chicago November 22nd of 2017?
I don't recall that.
Did you have relatives in Chicago?
No,
Have you been to Chicago in November? I'll withdraw that. All right, the next one appears to be Chicago APR training for mileage and hotel. What was that for? What was APR training again?
annual performance report.
Was that on behalf of the employer?
Yes,
The next one is self-monitoring Green Bay. Any idea what that was all about?
I don't recall. I'm I know we had to do self-monitoring training after some of the audits, just like we had to do the procurement.
You already testified that the Wisconsin Rapids trip was school business, is that right?
Yes.
Next is a management training in Bloomington, Minnesota. Was that on behalf of the employer?
Yes.
There's an unlabeled Minneapolis trip where you stayed at the Westin Hotel. Do you have any recollection of that?
I don't recall.
On 2/27/18, says there was an economics meeting. You requested mileage from Green Bay. Did you go to Green Bay?
I would assume I did, yes.
Was that on behalf of the employer?
Yes.
If you were had room service and some kettle chips, probably out of the mini bar, those were for you.
Yes.
What does the acronym IEDC stand for?
IDEC.
IEDC.
I really don't recall.
Okay. This says that on 3/22 and 3/23, 2018, IEDC Fed Forum, Washington, DC. Did you go to DC?
I don't recall. That. No.
Okay.
IE.
It says hotel, $376, a loft, Green Bay. Do you recall that?
I don't recall that.
Okay. Karen. Coachella. A music concert in Southern California has been provided. Do you have any recollection of whether you even attended that?
No, I did not go.
And if you did, it was not. Okay. If you did attend Coachella, was it for the employer?
No, that was not. It was, no.
Sure. All right. Says on May 2 of 2018, mileage to Columbus, Ohio for WHEDA, Wisconsin Housing and Economic Development Authority meeting in Ohio. Do you recall that?
I don't recall.
The next item is for June 6, 7, and 8, apparently, of 2018. For Wisconsin Housing and Economic Development Authority meeting dash HUD in Chicago. Is that for the employer?
Possibly could have been, yes.
You've already testified concerning the France trip. That was not employer related.
No,
Next on July 25th, you vouchered for a Monday through Friday in Chicago, July 2nd through 6th for a Chicago meeting. If you went to Chicago, was there a meeting involved?
yes,
A July 14, 15, Saturday, Sunday, Hampton Inn Duluth. Was that employer related if you stayed a weekend in Duluth?
no,
Recall anything about a July 5, I'm sorry, strike that, about a September 15, 16, Saturday, Sunday in Minneapolis? Was that employer related?
no,
Then you have a September 23, 24, 25, a Sunday through Tuesday. It says there was a Chicago APRIHP, and you stayed at the Wyndham Grand Hotel on the Chicago Riverfront. Do you recall that?
I don't recall, but it's possible that there was one there.
And if you filled out a voucher for a Chicago meeting, that's is that because you went to one?
Yes,
Next, you've got a Friday through Sunday, September 28, 29, 30th, where you stayed at the Edgewater Hotel in Madison. And denoted Madison APRIHP. If you recall, was there a meeting on Friday?
I don't recall, there could have been.
You went to Madison. Was that for the employer for the Friday portion?
It could have been, yes.
The next one is October 8 through 11. G2E, Vegas, Dwayne Emery. Do you recall what that was for?
G2E,
Yes.
I don't recall what it stands for.
And just a moment. No recollection of that one at all?
I want to say it's for the global gaming. G2E,
Was that for Dwayne Emery?
yes,
If you recall, the next one appears to be November 27 of 2018. Vouchered on November 19 of 2018 was, what does NOFA, NOFA stand for? If you recall.
I know it's like I don't recall. I know
Okay.
it's like for funds that are available.
This is for ICDB training, BG training in Oklahoma. Do you recall that trip?
ICBG. I know we were going to try to get that grant.
Do you recall going to Oklahoma,
Yes,
staying in a hotel one
I
night,
believe so. Yes,
work related?
yes.
There's a series of epic trainings. Did you go to numerous epic trainings?
Yes, it was the new system for HUD to report the IHP and the APR.
Okay. What is your educational background, Ms. Johnson?
Just high school.
Do you have any training for accounting? Did the tribe send you to the various trainings that were available to make your work more efficient?
Yes,
Were you sent so that you could fill out the appropriate forms for HUD?
yes,
How about the appropriate forms for WHEDA?
yeah, yes,
Is this something that fell to you in the office?
yes.
Did you apply for various grants?
Yes,
Turn your attention to March 7, March 10 of 2019. Do you recall Dwayne going to Green Bay?
I don't recall.
Okay. Next one is a state track meet / Chicago HUD review. If you recall, where was the state track meet in 2019?
I don't recall. I don't recall.
On June 11th of 2019, says report due HUD, Milwaukee. Did HUD have an office in Milwaukee that you had to report to?
No,
So were you working on a report that day, if you know?
I don't recall, but if it was, our IHP was due in June, I believe.
Okay. Now, Ms. Johnson, were there made known to you housing authority policies in place concerning reimbursement for personal travel?
I know that Dwayne had said that anything that was like pertaining to children or my children or any kids, it was an allowable cost. Whether it was in the policies or procedures, I don't know, but that's what he always told me.
Did anyone from the tribe or the housing authority provide you with a list of, any kind of a written policy?
No,
Were the vouchers for these multiple categories of expenses that I just went through with you, as the unauthorized mileage and travel, were the vouchers for those processed the same as all of the other vouchers?
yes,
Were the checks once cut, were they kept, such as the duplicate, were they kept in the same place as all the others?
yes,
Was there any attempt made to hide these?
no,
Let me ask you this, Ms. Johnson. Were these perks that seem to have been provided to you, did they keep you as a happy employee?
yes,
I want to turn next to the category that the tribe has labeled travel for the defendant's children's sports. This amounts to $35,159.96. Running from February 6th of 2015 through May 28th of 2019. Mr. Adams went through these with you as far as hockey camps, hockey games, travel to weekend tournaments. Do you recall all of that?
yes,
Were the vouchers for this travel processed in the same fashion as the other vouchers that we've talked about this morning?
yes,
Were they kept in the same place as the other vouchers?
yes,
Were they kept in the same place as vouchers you may have processed for vendors?
yes.
Tell me what a vendor was in the parlance of in the language of the housing authority.
A vendor would be anybody that we paid, cut a check to.
Would that be for someone who provided services to the housing authority,
Yes,
such as repairing a light fixture?
yes. Contractors, I mean, like Menards, septic pumping. There is hardware stores, just,
Whatever was needed.
yes,
And all these vouchers were kept in the same place,
yes,
available to Dwayne.
yes.
Did you make any attempt to hide these?
No,
When any of the checks would be countersigned by Natasha, she was your equal with it. Was she your equal within the housing authority?
yes,
As far as you know, did she have the same access to Dwayne that you did?
yes.
Did the housing authority have any policy established about the funding for works in writing?
Wayne always told me that it was an allowable cost.
I'm gonna move on now to home repairs and upgrades.
Your Honor, before Attorney Anderson moves on to his new category of expenses, I would just like to get a motion on the record to strike the statements that Ms. Johnson has made regarding when she proffers to the court that Dwayne told her that the youth mileage was an allowable expenditure. And then previously, when she made the statement while Attorney Anderson was walking her through the unauthorized travel, when she made a statement at the end of that category that Dwayne verbally provided authorization for the processing of those expenditures. I would like to formally on the record put a motion to strike to offer that to the court. Thank you.
My response would be that this is not timely. The items that the testimony she gave went on the record without objection at the time it was given. So this motion is not timely. It's already in the record without objection. So therefore, it stands. But I also think with a case such as this, where we have a trier of fact who is a judicial officer as opposed to a jury that would have to go through admissible, inadmissible, I certainly believe Judge Booley is capable of separating the wheat from the chaff as to what should and should not be considered part of the record.
Those statements were contrary to what I had asked you to do, not to do earlier. I told you that I did not want any statements from Mr. Emery to be uttered, and that's violation of, that's contradictory to what I asked before. So I'm going to grant these motions, but at the same time, I'm going to say to you, Attorney Anderson, it's already on the record, so I don't know how we strike it out of the record. However, it's not going to be a consideration as far as we go forward. So you may continue.
Thank you. Turning to the category of home repairs and upgrades. The tribe alleges $23,960.42. Do you recall that, Karen?
Yes.
Please explain to the judge the program that your home is enrolled in.
It is a mutual help program. And the way that I was told when I first got in it was that it was basically like a rent to own type program. And after 20 years, whether it was paid for or not, it would be turned over to the homeowner or the home, whoever had it.
Providing all the payments had been made.
When I was told about it,
Objection as to the form of the answer. It's hearsay. She is saying that she was told, but we don't know who told her this.
Attorney Anderson,
I'll withdraw. Karen, the home repairs and upgrades. First of all, make reference to one case, Unit L169 for modernization. What was your number? If you know.
I don't recall. It was either 169 or 167.
All right. From November 15 of 2016, there was a check drawn for $186.74 payable to you for a furnace call done by Wolk Heating and Cooling.
Yes.
Explain that.
I believe my furnace wasn't working and I had them come out and fix the furnace.
Now, from February 14, 2017 through February 22 of 2019. There's a series of checks that were gone through by Mr. Adams, all of which were Menards purchases. Were those purchases for your home?
Yes.
Is that home, or strike that, under questioning by Mr. Adams, do you recall using the term modernization?
Yes.
Had there been any modernization to speak of on your home from the time you acquired it in the mid 1990s until February of 2017 through February of 2019?
No.
Now, in two of those, there were purchases of mattresses, box spring, frame, and sheets. That wasn't used to modernize the home. Would you agree those are furnishings?
Yes.
Was this type of modernization available to other people that had the same type of home program that you did?
Yes, there was several that got their houses remodeled. I believe one even got a new house. There was decks built, wells fixed. Like I said, I know there was one house totally remodeled.
Okay. In two cases, actually, both on June 12 of 2017, there's about $7,300 worth of cabinets. Did you get new cabinets in your home?
I got new cabinets, yes.
Kitchen cabinets?
Yes,
Were these all kitchen cabinets put into your home?
they were, but I don't recall them being that much. I don't, yeah.
But if that's what got paid to Menards for your cabinets, apparently that's what you got?
Yes.
Did you get a new deck
Yes,
and work on your bathroom also?
yes,
How many bathrooms do you have in your house?
I have two.
Get new countertops for kitchen?
Yes.
You explained a little bit last week about your double entry patio door. Can you explain that again, please?
My patio door was not like the regular size of patio doors because it's like a prefab home, so like the doors aren't regular doors size wise, so they have to be special ordered through Menards at the time.
Okay. And you got a special order double entry patio door,
Yes,
and that replaced what?
the patio door that was there, that was like, it was kind of getting rotten around the edge or the sides of it.
Did it need replacement?
Yes. And so did my bathrooms too. The tubs were starting to leak.
Okay. Did you get anything extravagant into your home?
No,
Okay. June 13 of 2019, you had a service call for $105 with Maxwell Heating, service call to fix air conditioning. What was that all about?
I don't think it was to fix it. I think every year we had Maxwell Heating go and check the air conditioners just to make sure they were working.
Just a maintenance?
Yep.
Okay. Did you fill the vouchers out for these payments the same as you filled the others out?
Yes,
Did you put them in the same place?
yes,
Was there any attempt to hide them?
no,
Were they accessible to Dwayne?
yes,
Now, according to the next category, the tribe is alleging that you had $8,500 of equity withdrawals that you received from your home. Is that correct?
Yeah.
And according to the tribe's complaint, it appears to be that this would be an accounting issue. Would you agree?
yes,
Objection, the complaint speaks for itself, and the question calls for a legal opinion.
Attorney Anderson,
Well, I'll withdraw the question.
thank you.
Ms. Johnson, when you withdrew equity from your home, were you aware how the tribe handled the accounting on your payoff on your home?
no,
From May of 2014 through
Forgot to turn my phone off. Thank you for waiting.
from May of 2014 until May of 2018, were there in fact MEPA withdrawals on your home?
yes,
And if the complaint, which speaks for itself, paragraph 64, strike that. Ms. Johnson, if this was equity in your home, did you believe you had a right to withdraw it?
yes,
Did you attempt to in any way hide these vouchers?
no,
Fill them out as always,
yes,
accessible to Dwayne,
yes,
kept in the same place as the others,
yes,
no matter what they were for?
yes,
Okay. Turning your attention now to vehicle repair and maintenance. In a category amount of $2,432.21. You have already testified that there was a Traverse that Was that a housing vehicle?
Yes,
Have you ever owned a Traverse?
no,
There were, on June 26th of 19, there was $275 at Baronet Tire Depot. Brake pads, air filters, lug nuts for a 2015 Chevy Traverse. Was that your vehicle?
2015 Chevy Traverse, no.
There were also windshield wipers from Walmart on November 14 of 2018. Was that also for the housing vehicle?
I believe so.
Going back to July 1 of 2014, if you recall, Rice Lake Auto Air and Sound. Do you recall what that was for?
No, I don't recall that.
If you testified for repairs on a housing van, do you stand by that testimony?
I don't recall that one.
Ford Michelin tires on August 9 of 2016 at the Baronet Tire Depot. Do you recall that one?
Yes,
Who was that for?
I want to say that was for my vehicle, but well.
All right. Well,
but-
let me ask you this. How is it you used your vehicle for housing authority purposes?
Before the Traverse, the housing, I always had to, if we had to certified mail, I'd have to go to the post office. I had to go to the bank to do deposits. If I had meetings that I had to go to, I would drive my vehicle.
Did you go out on site to houses?
Once in a while we would go look at like houses that were being built.
Did you use your personal vehicle?
Yes,
Did you get reimbursed for that mileage?
yes,
Mr. Adams questioned you concerning why you would get your vehicle repairs done when you, and paid for by the housing authority, when you also got mileage. Do you recall that questioning?
yes.
Did anyone ever object to repairs that you got done on your personal?
No,
Did you fill these vouchers out in the same fashion you filled out all of the other vouchers?
yes,
Did you keep them in the same place?
yes,
Were they accessible to Dwayne?
yes,
Were they accessible to Natasha?
yes,
Did you make any attempt to hide them?
no.
I have no further questions.
Take a 15-minute break. When we come back, Attorney Adams, Ms. Johnson will be your witness.
Thank you, Your Honor.
Thank you, Judge.
Judge Bully, I just want to make sure, Blake Gross, yeah, Gross, is that someone, who should be in the Zoom?
Mr. Gross is, he's, excuse me. Thank you. He's here at my invitation.
Okay, I just wanted to make sure. Thank you.
Yes. Okay, let me. Not sure what we're doing here. We're back from recess. The defendant had called one witness, K.Johnson, and he had just completed his direct examination. Ms. Johnson is now subject to cross-examination by the tribe. Attorney Adams, your witness.
Thank you, Your Honor. Good morning, Ms. Johnson.
Good morning.
So, Ms. Johnson, in your direct testimony that that Attorney Anderson just walked you through, he asked you a question related to perks. Do you remember that question?
Yes.
And when he asked you that question, he essentially asked you, did you consider the payments that you received for, say, youth sports trips, mileage for youth sports, and the professional baseball and hockey games? Did he or did he not ask you if you considered those perks?
Guess I don't know what he was referring to.
But do you recall responding, yes, that those were perks, and as a overworked employee, they kept you happy?
I don't think he said overworked, but I remember saying yes.
So, Ms. Johnson, in terms of your happiness as an employee at the housing authority, did these additional expenses keep you happy?
Yes.
And can you explain why they made you happy?
I don't think that they actually made me happy. It was more, I think, more of a reward for doing good job at what I was doing.
So, Ms. Johnson, do you recall the salaries that other housing specialists were receiving from 2014 to 2019 while you worked there?
I don't think I was allowed to see what they were getting paid.
Okay. So, Ms. Johnson, would it come as a surprise to you if I told you that in calendar year 2018, you actually made more money off of what the complaint calls alleged unauthorized funds that you received than the reported income that showed up on your W-2 and 1099 miscellaneous? Would that come as a surprise to you?
Yes.
So, Ms. Johnson, can you tell me how much money you earned in reported income in 2018?
I couldn't tell you.
So, Ms. Johnson, your your total reported income in 2018 was $52,329.16. Does that sound about accurate?
Yeah,
And Ms. Johnson, when you add up all of the amounts that are listed in the complaint of alleged unauthorized funds that you received in calendar year 2018, you received $55,985.34. Do you refute receiving those funds?
no,
So, Ms. Johnson, in that year, you actually made more money off of mileage and trips and perks than you actually did off of your earnings related to wages. Does that strike you as being odd or surprising, or how does that make you feel now, like knowing that?
Objection to the form of the question and assumes facts, not in evidence. The alleged unauthorized, she has already explained away significant amounts of these. So the question itself almost seeks her to admit that everything was that is alleged unauthorized was in fact unauthorized.
Attorney Adams.
But Your Honor, Miss Johnson, through my direct testimony and this morning and through Attorney Anderson's direct testimony, admitted left and right that trips were not for business purposes and she couldn't recall purposes. So, I mean, I'm a little confused as to Attorney Anderson's statement that she's explained away most of these expenses.
I didn't use the term most.
I'm going to sustain the objection because I have to make a decision on how much of that is unallowable as we go along and how much of it will be allowable. So you're going to need to rephrase that question, Attorney Adams.
Miss Johnson, Miss Johnson, do you see this demonstrative chart that I'm displaying on the screen right now?
yes,
Can you see the large increase in income to you from 2015 and 2016 to 2017 and 2018? Do you see that increase?
yes.
Do you have any plausible explanation as to why your salary essentially almost doubled from 2015 to 2017?
Well, I would object. That doesn't appear to be the, I don't know if he's referring to the total amount shown.
The total amount of income, both reported income and complaint alleged funds, the total amount that Ms. Johnson received from 2015 to 2017.
So you're both the blue and the gold.
Yes.
So what, I'm sorry, what was the question?
Can you please explain to me how your total income, all of the funds that you received from the tribe from 2015 to 2017, how does that nearly double?
I guess I don't understand the question. I mean, you want me to explain why the alleged funds?
Do you believe that you are entitled to a double to the amount of money that you received from the tribe and the housing authority? Do you believe that you are entitled to doubling that amount of funds that you received from essentially 2015 to 2017 and 2018?
Objection relevance, whether she believes she was entitled or not, is not an issue in this case.
I'm going to sustain that objection, Councilman.
Ms. Johnson, would you please answer the question?
The objection was sustained.
I'm sorry, did you not hear that, Attorney Adams?
I'm sorry. So Miss Johnson, do you believe that you deserved this type of increase in income from 2015 to 2017 and 2018?
Objection irrelevant. Whether she deserved it or not is not an issue in this case.
I would disagree. It's actually the core to the case, whether she actually deserved to receive that income. It goes to the heart of the case.
Attorney Anderson?
Well, again, much like the court has already ruled that entitlement is not an issue, deserving is just another way of saying entitlement, that she should have gotten all of this or why it was processed as it was. So I just don't think it's relevant. What happened is relevant, not her opinion at this time.
I'm tending to agree with Mr. Anderson, Attorney Anderson on this one, so I'm going to sustain the objection and ask you to move along. Attorney Adams.
So Ms. Johnson, do you see this check number?
Yes,
Can you tell me this check number, please?
203682.
And Ms. Johnson, didn't you, in the direct examination that Attorney Anderson just put you through, did he not ask you about this expense related to maintenance on a Traverse
Yes.
in 2019?
Yes,
And didn't you testify that this was for a Traverse?
yes,
So Ms. Johnson, can you take a look at this document and tell me under the box model, what language is in that box?
it's a 2015 Chevy Equinox. It's for my vehicle.
So Ms. Johnson, can you tell me the what's written in blue ink on this invoice?
St. Croix Housing Authority, Traverse.
So Ms. Johnson, what vehicle was actually worked on for this $275 in 2019?
It was my vehicle.
And Ms. Johnson, didn't you just testify about 20 minutes ago that it was for the Traverse, that it wasn't for your Equinox?
Yes, but I didn't see that.
Then why did you testify to that then?
Because I took the Traverse in to get fixed at times. So he could have been talking about the time that I did take it in. But no, I don't have any proof or evidence for that either.
Ms. Johnson, you testified when I was asking you questions that you didn't know what the mutual help program was for tribal homes. Did you today testify that your home was in the mutual help program?
I've always said my house was in the mutual help program.
Well, didn't you testify as to you didn't know what policies controlled that program?
What policies? No, I don't know the policies. I know my house is in a mutual program.
So, Ms. Johnson, you testified today that equity payments were part of the policy. How can you testify to that effect if you don't know anything about the policy?
When I signed up for it, I was told that I could take money, equity money out.
And who told you that, Ms. Johnson?
The director at the time of when I signed up for it,
And who was the director at the time?
I don't know, I don't recall.
So, Ms. Johnson, the home that you're in, what year was it built?
I don't recall.
And Ms. Johnson, did you build the house or did one of your family members build the house?
No,
And Ms. Johnson, you said that the home was a prefab home.
yes,
How do you know that if you don't know who built the home?
because I was in the mutual help program, so I seen my house come in on a crane.
Ms. Johnson, doesn't that just contradict your testimony that you didn't know who built the home?
I don't know who built it. It was a prefab. I don't know who built the prefab home.
So, Ms. Johnson, was the home ordered for you?
I would assume so.
And did you order the home or did someone else order the home?
I would assume that the director of the housing authority did, just like it did for Reuben Buck, Ben Buck, and several other of the mutual help homes.
So, Ms. Johnson, the land that the home sits on now, was it previously owned by one of your family members?
Yes, it was.
So, Ms. Johnson, how did the land then come into the ownership of the St. Croix Housing Authority? Was it sold by one of your family members to the Housing Authority?
I think Michael Lowell just said that it was either you had to pay for it or contribute to it. So it was contributed to it.
Do you have proof of that?
No. But I'm sure the housing authority does. Just like it does with all of the other mutual homes.
Ms. Johnson, do you own the 40 acres that is directly adjacent to where your home sits?
I own part of it,
And who owns the other part?
my brother.
And Ms. Johnson, do you also own another 40-acre parcel that is near your home?
Yes.
Do you own it outright or with another family member?
It's in the middle of the land, so it would be landlocked, but it's just mine.
And when you say it's in the middle of the land, what do you mean by that?
Objection relevance. I don't see how this 40-acre parcel is in any way relevant to the series of alleged unauthorized funds.
Attorney Adams?
Ms. Johnson said, I wasn't the one that said in the middle of it. She said that. I'm just curious as to what she meant by in the middle of it.
Well, Judge, I allowed some questions about the land where her home sits, and I allowed the other questions, but I don't see how her other holdings are in any way related to this case.
I agree with that, sustain that objection. The 40 acres that's landlocked is not relevant to this particular matter at this time.
So Ms. Johnson, do you see this exhibit that is marked Exhibit 29?
Yes,
And Ms. Johnson, can you tell me what it says under special remarks on the payment voucher?
reimbursement wages.
And Ms. Johnson, are you familiar with this document, the St. Croix Tribal Court document?
Yeah, no, I mean, I don't recall it.
Ms. Johnson, do you see this document with the stamp of 377?
Yeah,
Are you familiar with this document?
I don't recall it, no.
Do you recall being sued in 2014 in state court and by a Unifund CCR LLC?
Yeah, that's probably right around when I was going through a divorce.
So Ms. Johnson, under it is ordered, judgment for money was rendered, granted, and entered on April 14th of 2014. Can you confirm that that's your name and your address?
Yes,
So Ms. Johnson, Ms. Johnson, this document here, can you read the language under to the debtor?
the creditor has been awarded a judgment against you as indicated below. The judgment has not been fully paid. The creditor has now filed a garnishment proceeding against your earnings from the garnishee. This means that the creditor is seeking to take some of your earnings to satisfy part or all of the judgment against you.
So Ms. Johnson, do you recall your earnings being garnished to satisfy this judgment?
Nope, I don't recall.
And Ms. Johnson, what are you looking at when you look down when I'm asking you questions?
I'm just looking down.
So Ms. Johnson, on this payment voucher, is that your signature at check or at program accountant signature and check processed by?
Yes,
And can you explain to me why it's a reimbursement for wages?
I don't recall.
So Ms. Johnson, would you agree with me or not agree with me that your earnings were garnished due to this domestication that was filed in the St. Croix Tribal Court? And then after the garnishment occurred, you then filed or requested a reimbursement for the wages that were garnished to pay that judgment?
Possibly, because I believe it was paid off.
So Ms. Johnson, can you explain to me the rationale as to why the housing authority would reimburse you for a garnishment to satisfy a judgment?
They're reimbursing my wages that were taken out.
Yes, why would the housing authority do that?
Because the housing authority paid my wages.
Ms. Johnson, the satisfaction of this state court case, this 214 SC 000324, how would the satisfaction of this state court judgment be a business expense for the housing authority?
It's not.
Then why are you seeking reimbursement for the garnishment?
For my wages that they took out.
Ms. Johnson, is that a business expense related to the housing authority?
It was my wages they took out.
Ms. Johnson, did Unifund CCR have anything to do with the housing authority?
I don't recall.
Ms. Johnson, you're not answering my question. Your wages were garnished for a state court action. So why would then the housing authority, why would you seek reimbursement of those wages that were garnished?
Because I believe that was already paid and they took my garnishment out. So I was being reimbursed for it.
So now you're saying that it was an improper,
It says
garnishment?
payroll took deductions out already. It was paid in full.
whose handwriting is that?
Mine.
Do you have proof that it was already taken?
No,
So Ms. Johnson, why isn't this document signed by your director?
because none of them are.
So Ms. Johnson, with none of them being signed, aren't they, where your director has not signed the payment voucher, aren't those incomplete vouchers?
Yes.
Then
but
why
like
are
I
the checks
said,
being processed? Ms. Johnson, I'll restate my question. If the payment vouchers are incomplete, then why are the checks being cut?
when I was taught on these, on the system, how many years ago, which I was told that I had to sign the vouchers.
Ms. Johnson, who told you that?
Barbara Vard did.
So now you're blaming Miss Barbara Vard for the checks being cut to you?
No, you,
Objection, irrelevant. Characterization of the word blaming.
Attorney Adams?
Your Honor, that was her answer. It wasn't, I didn't put that word in Miss Johnson's mouth.
I don't believe Ms. Johnson ever said blaming.
Attorney Adams, rephrase the question.
Miss Johnson, your testimony is that you were trained to always sign the check process by?
yes, when I was trained by Barbara Vard, who was part of Rick Peterson's financial, because I didn't know what I was doing down there. She told me the process of it, and she told me that I had to sign the voucher.
Whether there was a program director signature or not?
She told me I had to sign the voucher.
So, Ms. Johnson, my question though is, why are you creating checks to yourself where the voucher is incomplete?
I don't know, I don't recall.
And and Ms. Johnson, that applies to every single check, the $204,000 worth of alleged funds. That is your answer, that you don't recall?
Objection, that's not the state of the evidence. There are in fact checks that were signed that council proffered last week by Mr. Emery. So it's not all of them. There's also been an agreement that some of these, while I don't know how much of it dollar wise is going to have to be parsed out, but that the tribe has already agreed by a partial order that was sent, I believe, sent in this morning. So
I'll restate that. I'll restate that. So, Ms. Johnson, for every single check that you received where the voucher was incomplete, is your testimony now that you don't recall why the check then was cut?
When you say incomplete, what do you, I guess I don't understand when you say incomplete. When you
Ms.
say
Ms. Johnson, you agreed with me about 5 minutes ago when I said that if the program director has not signed the voucher, that it is incomplete. Did you or did you not agree with me when I asked you that question?
I don't remember you asking me that, or if that's what. But
So
yeah,
Ms.
Yes.
Johnson, with this payment voucher, if the program director's signature is not filled in, do you consider this payment voucher to be incomplete?
do I consider it incomplete? No, because none of them would be incomplete, or they would all be incomplete. He was never around to sign any of them, like I told you before. Any contractors, hardware stores, septic plumbing, any of that. He was never around. So in hindsight, I should not have paid any bills whatsoever.
Is that your testimony, that in hindsight, you should not have paid any of the bills previously?
Well, if they're incomplete, as you're stating, then I shouldn't have.
And that includes yourself, correct?
Correct. But then there would have been nothing paid. Like I said, no vendors, no contractors, no hardware stores, the Menards bill, anything.
So Ms. Johnson, is that your testimony now, that that's your excuse, that because Dwayne was not around, that the checks had to be cut anyway, whether it was to Menards or to you, and that's why they were cut?
I was told to cut the checks, but no, I don't have proof, so.
So Ms. Johnson, then isn't it just kind of a clear situation of your word against the evidence?
Yeah,
And so, Ms. Johnson, if it's your word against the evidence, how do we explain, or how should, or strike that? Let me restate it. So, Ms. Johnson, if it's your word against the evidence clearly shows that you were committing a fraud against the housing authority. Would you
Objection to
agree
the
with that
fraud.
or not?
Objection to the form of the question. She has not admitted that she's committed a fraud against the housing authority. The evidence does include not only documentary evidence, but the evidence given by Ms. Johnson. Her testimony is in fact evidence also. And the question itself invades the province of the fact finder, as it is a calls for a legal conclusion. So for all those reasons, I object to the question.
Attorney Adams?
Your Honor, I can rephrase the question.
Thank you.
So, Ms. Johnson, if the payment voucher is not signed by your program director, who else did you run payment vouchers by?
Nobody. He was my director and the boss. There was
So,
no one.
I'm sorry, go ahead.
Let her finish. Thank you.
There was no one else there to run them through. He was my boss.
And Ms. Johnson, didn't you testify earlier today that nobody was below Dwayne?
Yes.
So, Ms. Johnson, I'm confused then. So why would you say then he's your boss?
Because he was the director.
Then, Ms. Johnson, then why did you testify that nobody was below Dwayne?
Below, as in meeting no one, if he wasn't there, there was no one else to go to. There was no assistant director or anything like that.
But Ms. Johnson, didn't you have other resources available at your disposal? Didn't you have the tribe's finance department?
No.
So, Ms. Johnson, you couldn't, if you had a question about fiscal management at the housing authority, you couldn't pick up the phone and call someone at the tribe's finance department?
I could probably try, but they would never return my calls or emails or no.
So, Ms.
No.
Johnson, isn't like lack of response the same excuse that you had for driving to Chicago to speak with HUD officials?
Objection, argumentative.
Overruled. Answer the question.
What was the question?
Ms. Johnson, you just said that the finance department folks would not get back to you, so it didn't make any sense to give them a call. And did you not earlier today testify that you drove to Chicago to get the attention of HUD officials that also would not return your phone calls or return your emails?
Yes, and I didn't say it didn't make sense, but I guess once you bang your head up against the wall so many times, especially with Rick Peterson, who would never answer my questions because I wasn't the director, so he would never answer my questions because I was not the director and he wouldn't talk to me.
So Miss Johnson, earlier in when Attorney Anderson was asking you questions, he asked if anyone objected to the vouchers, correct?
Correct.
So, Ms. Johnson, where a voucher does not have a program director signature, then how do we know whether someone objected or objected to it or didn't object to it?
Calls for speculation, objection.
Attorney Adams?
Your Honor, the witness testified that no one objected to the vouchers, and I'm just kind of curious where Ms. Johnson signs at the program accountant signature and then also signs at the check process by sign, how she can say that no one objected to it when she is the only one that has control over the document.
Attorney Anderson, you got a response?
Well, I believe her testimony last week, or perhaps it was earlier this week, was that the countersignature of another employee was placed upon the check itself, which was, as I see it from the copy, with the voucher. So someone did have an opportunity, the countersignature.
Your Honor, I would respectfully point out to the court that that is a new, that the witness has not testified to that fact, and that's a legal theory that Attorney Anderson is proffering to the court.
Attorney Adams, let Attorney Anderson finish his statement. Attorney Anderson, are you complete with your statement?
I am.
All right.
And that actually was not my question, Your Honor.
Right. I'm going to overrule this objection because I kind of want that answer also. So the objection is overruled. Please continue. Restate the question so the defendant is clear what the question is.
So, Ms. Johnson, you had testified that no one objected to the vouchers, correct?
Correct.
My question, Ms. Johnson, is if you're the person who is requesting the check and you are processing the check, how do we know that someone did not object? Based on the payment voucher.
My office was always open in the morning, so Dwayne had access to go in there and look at whatever he wanted. And I would assume if he disagreed with anything, he would have told me. No, I don't have proof of that either.
So, Ms. Johnson, is essentially your testimony then that if you sign the payment voucher at program accountant and then you sign at check process by, that it was either Dwayne or somebody else's responsibility to then check or to review whether you then actually created the check?
I'm the only one that ran checks there. Tash had the ability to do it, but she never did.
But that doesn't answer my question, Ms. Johnson.
Well, I don't know what your question is or what.
So, Ms. Johnson, you testified that your office was always open. Dwayne could come in and take a look at the work that you're doing. So essentially, is it your testimony that, and I'm just trying to make sense of it, that it was Dwayne's responsibility to essentially monitor every check that you created that did not, that was the result of an incomplete payment voucher?
Well, he was the director.
That doesn't answer my question, Ms. Johnson.
He was.
What? I'm sorry, go ahead. Go ahead,
No.
sorry.
Oh, go ahead. I don't.
I'm trying to be patient and wait for an answer.
I guess I don't understand the question.
Okay, Ms. Johnson, I'm gonna do my best to kind of explain it, or like ask the question as clearly as I can. So, Ms. Johnson, did you, about, I don't know, 5-10 minutes ago, essentially testify that your office was open and anybody could see what payment vouchers you were working on?
Yes, he had a key so he could get into the office.
Okay, so we've established that he had access to your office. Is it your testimony that when a payment voucher is not signed by Mr. Emery, but you then create the check, is your testimony that it was his responsibility to actively monitor what checks were being created?
Yes.
So, Ms. Johnson, why, that doesn't make sense to me. Why would the check be created if Mr. Emery did not sign the payment voucher?
Because he would always tell me to get the bills paid. And no, I don't have proof that he said that.
So again, it's your word against the evidence then, correct?
Yes.
Objection is the characterization of what is the evidence.
The evidence of incomplete payment vouchers.
And the evidence of her statement as to how that happened. It's all evidence. It's for the court to
In your defense, Attorney Anderson, you haven't provided any evidence to the contrary.
It's the burden of the tribe to prove the case.
Well, I think we have, where she scratched off Equinox and wrote Traverse.
As to that particular one.
Well, I think in all of the ones where she admitted that she doesn't know whether it was a business trip or not.
Well, that's argument you can make in a closing statement or closing argument written. I don't know what the court's going to require. But yeah, you can make these arguments. I can make mine.
So, Ms. Johnson, Ms. Johnson, can you explain to me what your belief of mileage is when you're using your own personal car for work-related purposes?
Exactly that, mileage.
But I'm asking, what does that mean to you?
Mileage,
Does the mileage represent just gasoline, or does it also represent depreciation and routine maintenance on the vehicle?
I would think mileage would be mileage.
Can you define mileage for me?
Mileage, the miles you go?
Are you receiving monies for that mileage?
Yes,
So Miss Johnson, what is the basis? Like what let's say in one of those years, the IRS mileage rate was 55 cents a mile. Does that sound about right?
I couldn't tell you. But
Would you disagree that it would be somewhere around 55 miles or 55 cents per mile?
probably,
Okay. So Miss Johnson, what does that 55 cents per mile represent to you? Is it just the cost of gas?
that's what I was always told.
And who told you that?
Dwayne. No, I don't have proof.
Did you ever do any of your own independent research, Miss Johnson, into what the definition of, or what that 55 cents represented on a per mile basis?
No,
And why not?
I didn't think I had to.
So Miss Johnson, then would it be fair to assume that you were filing mileage reports that were inaccurate?
I did them as I was told.
So Miss Johnson, would it come as a surprise to you now if I told you that the 55 cents per mile was to include, it was a calculation of the fuel, routine maintenance, and depreciation that your vehicle would encounter by traveling that mile, that the Internal Revenue Service ascribed essentially an amount for that particular mile?
Objection, Mr. Adams is testifying.
I'm just asking her if it would surprise her.
That's why I took it to objections overruled. Please answer the question.
Yes,
And Miss Johnson, would it come as a surprise? Because from my standpoint, you were receiving mileage, but then you're also, which should include routine maintenance or account for routine maintenance, but then you are getting reimbursement for actual maintenance to the vehicle.
Same objection that Mr. Adams is testifying. Providing facts, not evidence.
Attorney Adams, give an example of the question.
I'm sorry, what was that, Judge?
Give an example of the question.
Yeah, you know, Your Honor, I know that there was some mileage backup documentation that Miss Johnson filed where there was essentially a print off of the IRS mileage calculation. And maybe what I can do is over the lunch break, I can find one of those and we can come back to this line of questioning later.
Let's do that. Move on
Okay.
then.
Okay. Yes, sir. So Miss Johnson, when it comes to the Hawaii trip, I don't recall during my direct testimony or my direct questioning of you related to the Hawaii trip in March of 2016 that you told me that that was for a training. So is it your testimony now that that trip in March of 2016 where you sought reimbursement for $900 for the Go Oahu card, is it your testimony now that that was for work-related purposes?
Yes, that was an, I believe, an Amarin conference there.
So Miss Johnson, if that was a work-related trip, why aren't there hotel charges and like say airport parking charges that were also part of the trip?
Because there should be. That's probably just for the pass.
So Miss Johnson, can you explain why the backup documentation does not provide any description of the business necessity for the trip?
No,
And can you provide to me an explanation as to why the payment voucher does not contain any explanation of a business related activity?
no,
And Miss Johnson, is there, do you recall filling out a St. Croix travel reconciliation, form for this Oahu pass?
no,
And Miss Johnson, have you provided any other evidence to substantiate that the trip to Hawaii in March of 2016 was for business reasons?
no.
Okay, Miss Johnson, Attorney Anderson on his direct questioning of you, he discussed this iPhone 6 repair. And I just want to So Miss Johnson, can you tell me the amount of this check?
177.85.
And Miss Johnson, can you tell me what it says at line item?
Mileage.
And Miss Johnson, can you tell me what it says under remarks?
Mileage, post office, and phone repair.
Okay, so Ms. Johnson, is there any reason why it says mileage to the post office, but this was actually, but instead, for the backup documentation, you've got a receipt for what looks to be stamps?
Probably because I bought stamps.
So why does the payment voucher say mileage then, Ms. Johnson?
A mistake.
And Ms. Johnson, on the receipt for the computers, can you tell me what it says under item number?
It
Council,
says-
could you repeat the question? I was looking, trying to spot this on the screen.
This is exhibit 33. It is Bates number 405. I've blown up the Stope computers receipt and I've asked your client what it says under item number on the receipt.
Says iPhone 6.
What does it say next to iPhone 6?
Digitalized LC.
So what is this receipt for, Ms. Johnson?
I cracked my phone.
Why doesn't the receipt say screen repair?
You would have to ask that Stope Computers.
Was this your own personal phone, Ms. Johnson?
Yes, it was.
So can you explain to me why the housing authority is paying for repairs to your own phone?
Because I used my phone for work.
Was every phone call placed on that phone for business related purposes, Ms. Johnson?
A lot of them.
Please just answer his question.
Not everyone, no.
Ms. Johnson, your attorney asked you about some of the NHL games that you attended. Are you a big hockey fan, Ms. Johnson?
When my daughter was in hockey,
You didn't answer my question.
when my daughter was in hockey, yes, I was a fan. Because my daughter loved hockey.
So is it safe to assume, Ms. Johnson, that your daughter was with you on this trip?
Probably.
And Ms. Johnson, on this payment voucher, where it says invoice number, can you tell me what it says on that line?
SMNENT.
Can you tell me what that means, please?
I'm assuming reimbursement.
And Ms. Johnson, would you agree with me that so can you tell me the order date on this receipt?
12/11.
And when is the game?
February 8th.
Okay, so Ms. Johnson, it would be safe to assume that this wasn't just some spur of the moment purchase, correct?
No, but like I told my attorney that there were times when Dwayne told me that I could take my kids.
And what was the reason why Dwayne said you could take your kids?
You would have to ask him.
And Ms. Johnson, why did you want to take your kids?
Because Mackenzie loved hockey.
And was this one of the perks that you talked about before?
Possibly, yes.
And Ms. Johnson, when it comes to baseball, are you a big baseball fan?
No, but my son was.
So, Ms. Johnson, would you agree with me that the baseball games were perks as you described them earlier?
Possibly.
Ms. Johnson, did you call them perks previously?
Did I call them perks? Or did I agree that they were perks?
Did you agree that they were perks?
Yes.
So I'm gonna ask the question again, Ms. Johnson, because you agreed to that statement or that question that was asked by your attorney, and it was asked in kind of a general fashion. Would you agree or disagree with that?
Agree.
Okay, so for what I'm asking is not generally, but specifically, when it comes to this Brewers versus Cubs game, where they were providing the final out bobblehead giveaway on May 20th, do you consider this to be one of the perks that you received as an employee?
Yes.
So, Ms. Johnson, I'm going to bring up one of the trips that Attorney Anderson asked you about before. And Ms. Johnson, on this document, can you tell me the cost of the hotel?
$17.50.
And Ms. Johnson, do you recall if it was for multiple rooms or one room?
I don't recall.
Ms. Johnson, do you see this document?
Yep.
Under Hilton, Chicago, Michigan Ave Cultural Mile, can you tell me how many rooms are indicated?
One room.
So Ms. Johnson, on the right-hand side, under price summary, would would you agree or disagree that the cost per night of the room is $583.50?
Per night? No, that's the total.
If that is the total for the stay, Miss Johnson, then why does the payment voucher have $1,750.50?
I don't know. I don't recall.
So, Miss Johnson, I know that I'm not an accountant, but if you multiply $583.50 by 3, you do come to that same amount of $1,750.50. Does Attorney Anderson have a calculator there at the office, or do you have a phone where you can multiply $583.50 by 3?
Well, I'm sure that's probably what I did. I don't remember doing it. Yeah, it comes to 1750.50.
Okay, so do you want to restate your prior testimony that was not the price per night of the hotel room?
I don't know. I don't recall that. And if it, yeah, if 583.50 is a night, but it says 3 nights there, so I don't know. And it may have been a mistake.
If it was a mistake, Miss Johnson, do you recall reimbursing the tribe for the difference?
I don't recall, no.
If it is accurate, Miss Johnson, and I mean, the document does speak for itself, can you provide to me some reason why the housing authority is spending $583.50 per night for a room in Chicago?
I'm gonna object. That misstates the plain face of the exhibits, as well as the indication that it's for 3 nights and apparently in multiple rooms.
Attorney Anderson, where does it say multiple rooms?
When you did the math, counsel, that's where I come up with it. It has a per night price, or an average per night.
As I'm looking at it and the way the math comes out to me, it's 583.50. This is 1 room for 3 nights. The argument that Attorney Adams is making is that's how we came up with the number at the beginning. So I'm allowing him to explore that. Unless Attorney Anderson has an optional explanation of this, I'm going to allow Attorney Adams to continue with his line of question. So the objection is overruled. Please continue.
Thank you, Your Honor. Miss Johnson, was this a business-related trip?
I believe so.
Do you recall what the business was for?
No,
And the backup documentation, Ms. Johnson, it does not confirm a business related purpose? Would you agree or disagree, Ms. Johnson, that it includes a business related purpose or evidence of a business related purpose?
I would agree.
You would agree with what?
That it wasn't a business, you just.
So, Ms. Johnson, if this was not a business related purpose, then why are you receiving a check for $2,358.30 for the trip?
I don't recall.
Do you recall this particular hotel, Ms. Johnson?
No, I do not.
Do you recall if anyone traveled with you on this trip, Ms. Johnson?
No, I do not.
Was this a misappropriation of funds from the housing authority, Ms. Johnson?
Not that I recall.
Ms. Johnson, this exhibit 46, the check says that it's mileage to Duluth and it's hotel in Duluth. And Ms. Johnson, can you tell me on the payment voucher where it says line item, can you tell me what that says?
Regional meeting mileage, Shell Lake Bank.
And Ms. Johnson, on the right-hand side of the document where it's got invoice number, do you see mileage and hotel or motel?
Yes.
Can you tell me the date next to the dollar amounts, Ms. Johnson?
1116.
And Ms. Johnson, would it be common for a regional meeting to happen on New Year's Day?
I don't remember. I don't recall.
Did you, Miss Johnson, did you commonly work on New Year's Day when you were working for the housing authority? Was that a work day for you?
Objection. No, I'll withdraw that objection.
I worked a lot of holidays.
Would you normally go on business trips on a holiday, Miss Johnson, for a regional meeting?
I don't recall when their meetings were.
And Miss Johnson, I'm gonna go back to this, this Chicago trip that we've already established was not for business purposes. Do you see the dates, Miss Johnson, under Hotel Chicago, Michigan Ave Cultural Mile? Do you see those dates?
Yeah, July 5th.
So Miss Johnson, would it be safe to say that this is the time period immediately after July 4th of 2018 or 2017?
Yeah,
So did you go to Chicago for 4th of July kind of weekend related activities with family members?
no,
Can you tell me the purpose of the trip?
I don't recall.
So Miss Johnson, if you don't recall the purpose of the trip, then how can you tell me that it was not for a business related purpose?
Objection to the form of the question. I didn't understand it myself.
Restate the question, please.
Miss Johnson, did you or did you not previously testify that this trip to Chicago in July of 2017 was not for business related purposes?
I said I didn't recall. I don't remember if it was or not.
So Miss Johnson, if you can't recall whether it was for business related purposes, then would you agree or disagree that it potentially could have been for personal reasons?
Disagree.
And why would you disagree that it could not be for personal reasons?
I'm sorry, what was that again?
Miss Johnson, if you can't recall the purpose of the trip, then how can you tell me that there's no chance that it wasn't a personal trip?
Because I don't recall. I don't know if it was for work or if it, I don't recall if it was for work.
But you don't recall if it was for a personal reason, correct?
Correct.
So Ms. Johnson, Attorney Anderson asked you about this trip to Las Vegas. Do you remember this in 2017?
Yes,
And do you recall testifying previously that this was that there was no housing related business related to this trip?
yes,
So, Ms. Johnson, if there was no housing related purpose to this trip, why did you go on the trip?
because I was told to go.
And Ms. Johnson, can you explain to me why this payment voucher was altered in handwriting to change the amounts?
Sometimes I did that when I seen mistakes, or I just did it by hand.
And Ms. Johnson, why isn't this travel reconciliation also changed to account for the handwritten revisions that were done on the payment voucher?
Probably because I didn't see it.
Did your children travel with you on this trip, Ms. Johnson?
I don't know. I couldn't tell you.
Any explanation, Ms. Johnson, as to why the meals and incidentals on this travel reconciliation that's dated September 19th of 2017, and then this one that is dated October 1st to October 4th, why the meals and incidentals goes up by $500 through handwritten revision?
No, I don't recall.
So, Ms. Johnson, when it comes to meals and incidentals, do you recall if this is calculated on a per day basis?
I don't recall.
So, Ms. Johnson, again, I'm going to go back to the Chicago trip as kind of a reference. Do you see this printout, Ms. Johnson?
Yes,
Would you normally refer to the United States General Services Administration for helping provide guidance when it comes to meals and incidentals?
I would look it up on the internet.
Okay, and is that your handwriting on this document, Ms. Johnson?
Yes,
So, Ms. Johnson, do you have any explanation as to why on a trip to Las Vegas, there's no justifiable reason or any explanation as to why the meals and incidentals for 3 days would be calculated at $241.33 per day?
no, I do not.
Do you know, Miss Johnson, if meals are significantly more expensive in Las Vegas as opposed to Chicago?
I don't know. I couldn't tell you.
Miss Johnson, how much do you spend in groceries on a monthly basis? Say in April of 2022, how much did you spend roughly in groceries for your home last month?
Objection, relevance.
Attorney Adams?
Well, I think it is relevant, Your Honor, because in the Chicago trip, she has $192 for 3 days in Chicago, Your Honor. But for a trip in the same year to Las Vegas, again, I'm not an accountant, but if you divide $724 by 3 days, it comes out to $241.33 per day. I'm just kind of curious in relation. I mean, I don't understand why one individual would need $241.33 per day to eat in Las Vegas.
And her home grocery bill has nothing to do with either of those numbers.
I agree with Attorney Anderson on this one. Objection is
Okay,
sustained.
all right. So Miss Johnson, do you have any explanation as to why the meals and incidentals per day in Las Vegas would per day would be more than the entire 3-day trip to Chicago that you went on in that same year?
No, I do not.
Do you recall if you made this manual change on this document to change
No.
it?
No, I don't recall.
And Miss Johnson, when it comes to the music festival trip to California in 2018,
Excuse me, Counselor,
yes.
are you going into another area?
This is still trips, Your Honor. But once I get done with this one, then I was going to transition. And I wasn't going to spend a lot of time on this one, Your Honor.
All right, continue.
Okay, thank you. So, Miss Johnson, do you recall on direct examination when I questioned you about Coachella, and I pointed out to you that at your deposition back in January, you testified under oath that you actually did it. You did travel for this this music festival. Do you recall that?
Yeah, yes.
And can you please explain to me the discrepancy in your testimony from the deposition to like this trial that's occurring now in May?
I think I told you before that I didn't remember what that was, but after leaving the first one, I remembered that I didn't go to that one.
Did you alert your attorney about the discrepancy after the deposition?
No, I did not. I didn't know I had to.
Ms. Johnson, when it comes to capital marketing concepts and Cumulus Minneapolis, do you know if either of these entities paid for any of the travel expenses?
Not that I know of.
Is it possible, Ms. Johnson, that they paid for the rental car where it says rental car requested and it's circled yes?
I don't think they paid for anything because I didn't go. That was a form that I had to fill out that they sent me.
So, Ms. Johnson, if you didn't go, then why did you testify at the deposition that you did go?
I just answered and said that I didn't remember what that was. When I left, a couple days afterwards, I remembered what it was, and I remember I didn't go. And no, I did not tell my attorney because I didn't think I didn't know I had to. And that's the one that I also said that I paid back, but no, I don't have proof of it either.
Your Honor, I'm done with the unauthorized travel questions.
Okay, we're gonna take a longer lunch day. We're gonna, we'll lunch until 1:45. So you see you guys back there. We're gonna recess now for lunch and back at 1:45. We come back, the witness is still subject to cross-examination by Attorney Adams. We'll see you after lunch.
That's good for you. Should be. We opened the heat vents, but yesterday was Thanksgiving.
And today it's free.
These are Roxical mix.
Oh, no,
That's wrong.
Oh, I got some.
Okay.
Is everyone here?
Anderson and his client are here.
Yeah, the tribe is present, Your Honor.
All right. You were back from lunch. As I understand it, where we are right now is the tribe is in the process of cross-examining Ms. Johnson. Mr. Attorney Adams, you may continue.
Okay, Your Honor. And actually, Your Honor, I believe that I am done with my cross-examination of Miss Johnson. So I don't have any further cross-examination questions for her.
Attorney Adams, do you have any redirect?
Adams or Anderson?
Attorney Anderson, sorry.
No, I do not. And the defense rests.
Does the tribe have any rebuttal witnesses?
No, Your Honor, we're prepared to provide our closing arguments to the court.
Give me a second, pull this together. Okay, so the defense rests with one witness. The tribe has no rebuttal witnesses, so that pulls us into the closing arguments. So at this particular point in time, Attorney Adams will present his closing argument. After Attorney Adams presents his closing argument, Attorney Anderson will be given his opportunity to present his closing argument, and then we'll go from there. Right, Attorney Adams, do you want to present your closing?
Yes, Your Honor. Thank you for the opportunity to present the closing. I would like to start off with 4 major themes, if you want to call it that, Your Honor, that I believe that the court, I don't believe the court has to consider. I know that the court has to consider, but 4 major argumentative themes that the tribe presents to you now, and I humbly argue that that the tribe has successfully argued to the court by satisfying the burdens of proof and persuasion that are needed in this case. And those 4 argumentative themes, Your Honor, is that the first one being is that the defense that K.Johnson has presented to the court is essentially her word against thousands of documents and 2 credible witnesses. The second one, Your Honor, is that K.Johnson's actions harmed the tribe's housing authority and tribal members in general. The third, Your Honor, is that a Nuremberg defense is extremely convenient since it has been proffered as a defense. It's the only defense that has been proffered by Ms. Johnson and her counsel. But the problem with that defense, Your Honor, is that she directly profited from the actions she committed. The third one, Your Honor, is that K.Johnson was motivated to profit from her position of authority and privilege. That this is a story of misappropriation and greed, Your Honor. As shown earlier, this demonstrative exhibit clearly shows that K.Johnson's monies that she received from the tribe, from both reported income and the funds that have been alleged in the complaint to be unauthorized misappropriation and essentially fraud committed against the tribe, that the total dollars that she received from the tribe and the housing authority essentially double from 2014 and 2015 to 2017 and 2018, with no plausible explanation, Your Honor, from the defense concerning, did she deserve those funds? Was she entitled to those funds? But the far stronger piece of this whole situation, Your Honor, is that the same person who is requesting the funds is the person who is creating the check in a vacuum with no evidence presented to the court, Your Honor, that there was any oversight of those check creations. And the witness has consistently testified over the 4 or 5 days that we've been in trial that a lot of these were mistakes, that she was told she was able to do it. But we have not been provided from the defense, Your Honor, any reasonable and prudent explanation as to whether these were properly authorized distributions and any business nexus between $583.50 a night hotel rooms in Chicago to a business need for her to be there in Chicago on the housing authority's dime. Your Honor, the court has heard testimony from the defendant as to how she received over $200,000 in unauthorized payments from the St. Croix Housing Authority. Over and over, Your Honor, we have heard the defendant testify that she was quote unquote told by her past supervisor, Dwayne Emery, that the costs were allowable, that he encouraged her participation in youth sports and her traveling to youth sports, that Dwayne could do whatever he wanted with quote unquote tribal funds. K.Johnson has also provided contradictory testimony as to whether she had the housing authority pay for her travel to attend a Southern California music festival, why she attended professional baseball and hockey games on housing authority funds, why she was purchasing expensive Apple iPhones for family members with housing authority funds, why she was traveling to Las Vegas to attend gaming conferences funded by the housing authority, but through testimony has said that they had no business nexus to housing authority programming, why she was traveling to Chicago every other week for phantom epic trainings on CPR utilizing housing authority funds, and why she was falsifying vehicle registration documents to cover $75 worth of tabs for a Jeep that she testified was hers, to name a few, Your Honor. And if I may, I would like to go through what I consider to be, for argumentative purposes, the greatest hits of these exhibits, Your Honor. The first one being Exhibit 17. We have payroll that is being processed outside of the electric payroll system for Miss Johnson for 64 hours at the tune of $1,280. There is no employee signature or supervisor signature on the timesheet, and the only signatures on the payment vouchers are hers, Your Honor. I would argue to you that this was done in a vacuum, and she did it on purpose to avoid scrutiny, and it was a misappropriation of funds. Your Honor, Exhibit 29. Ms. Johnson testified today in a roundabout fashion that she wasn't very familiar with this Wisconsin state court case where a judgment was entered against her and her wages were garnished by the St. Croix Tribal Court, and it was effectuated through payroll. And when asked, why are you getting a reimbursement for garnished wages for expenses that have nothing to do with the St. Croix Housing Authority, we have K.Johnson testifying, well, my wages were garnished and this is a reimbursement for it. She never answered that question directly, Your Honor. We have Exhibit 32 in the amount of $900, Your Honor, for passes in Hawaii with no discernible housing authority related purpose. The first time in 4 to 5 days of testimony that we hear from K.Johnson that this was a work-related activity was conveniently during the direct testimony that she provided during questioning by her attorney. Your Honor, we have Exhibit 35 in the amount of $712.45 for a Chicago trip with no discernible business nexus, but for 2 tickets to a baseball game, each totaling individually $356.22, Your Honor. I would ask any reasonable person how this is related to housing St. Croix tribal members. Your Honor, we have Exhibit 54, which is a check in the amount of $1,872.73, where the defendant, K.Johnson, has testified that this had nothing to do with the housing authority, that she was told she could go. I wonder, Your Honor, if K.Johnson were told, if she were at the St. Croix Casino by Dwayne Emery, that if the door is unlocked to the cage, that it's okay that she goes in and takes cash in the amount of $1,872.73 just because Mr. Emery said it was all right. That is not a defense, Your Honor. That is not an excuse to say that an individual told me I could go ahead and do it. There is no individual personal agency, or at least K.Johnson would have us believe that she doesn't have a mind to think for herself. She has no personal agency in a situation like that. And she was without the ability to say no. Your Honor, we have Exhibit 56, which is essentially a double dip. And K.Johnson admitted that it's a double dip of travel on a trip that she shouldn't have been on in the first place because it had nothing to do with the housing authority. Or if she was on the trip, she should not have been seeking reimbursement for the same itemized expenditure as she did previously. Your Honor, at its core, this begs a credibility question. If we are to believe that what K.Johnson has told us is true, that we are supposed to embrace that defense, and the defense is her word against all of these documents and 2 credible witnesses, how is a reasonable person to do that when she is providing contradictory testimony on the record? Your Honor, she was sworn in at a deposition in January and provided testimony to the tribe that she attended the Coachella Music Festival in Southern California. But now we are left to believe that she had a change of heart, that she had a different recollection after the deposition that informs her memory that she didn't attend. But no communication from her or her counsel providing an errata sheet to the deposition to correct that statement. No discovery
of his closing argument. Errata sheet is not a Wisconsin procedure, nor is it a procedure of the St. Croix code. That's a Minnesota thing.
No updated discovery responses, Your Honor, and I'm sure an update to a discovery response is a Wisconsin thing. Would you agree with that, Attorney Anderson?
If there were any updates,
Then why didn't the tribe receive an update after your client recalled that her testimony was untrue during the deposition?
it is not updated discovery to provide further information from a deposition.
Your Honor, we didn't receive it because we never received one document from Karen Johnson through her attorney through the discovery process. Not one document, not one piece of evidence, Your
Counsel,
Honor.
counsel,
Can I please finish?
Gentlemen,
It's
No,
a
I have
true
to-
statement.
gentlemen,
It's a true statement.
gentlemen, hold on. This is Attorney Adams' time to make his statement, his closing argument. Do not interrupt. If you have a problem with what he's saying, and it's your turn to make your closing argument, you can respond, Attorney Anderson. Please continue.
Thank you, Your Honor. It is a true statement. I will position my words to the record that we never received a one page of evidence besides her own created discovery responses, but we didn't receive one page of discovery in this case, Your Honor. And I believe it's very telling that Karen Johnson has not proffered any other witness to testify on her behalf in this case. We haven't even gotten a character witness to discuss her as an individual, as a person in this case. We have not received a factual witness to corroborate anything that she has said. Your Honor, we have Exhibit 103 in the amount of $975.22 for hotel rooms, for youth travel, for sports travel, with no business nexus. It's her word against, or we're supposed to believe her at her word that this was approved and that this wasn't, it was okay to do this. Again, I ask, Your Honor, how this expenditure helped the housing authority provide safe and quality housing to tribal members. We have Exhibit 120, Your Honor, in the amount of $767.99, again, for youth-related travel concerning wrestling matches and hockey tournaments. How is this furthering the goals of the housing authority to provide safe and quality housing to tribal members? How is this related to furthering those goals when the person who is requesting the check and processing the check is profiting from the check? Your Honor, in 2017, Ms. Johnson had over $100,000 in funds she received from the tribe. She was being paid nearly $60,000 in salary from the tribe. With $60,000 in salary that she's receiving for her work, Your Honor, why is it the housing authority's responsibility to pay for this mileage for her family's youth sporting activities? And Your Honor, I will note that You may hear from the defense that this happened with other individuals at St. Croix, but the one huge glaring difference between this case and others is that we have the fox guarding the hen house in this situation, Your Honor. We have the person who is receiving the check is asking for it and actually cutting the check. That is a glaring difference, Your Honor, from any other examples that the defense may try to raise with the court. We have Exhibit 131, Your Honor, $855.36 for mileage to Minnesota that only benefits the defendant and her family. Your Honor, with Exhibits 172 and 173, we have the defendant, we have K.Johnson authorizing over $8,000 worth of cabinetry for her home. $8,000 in cabinetry. If that isn't an exuberant luxury, I don't know what is, Your Honor. Your Honor, we have an equity disbursement from Miss Johnson's home in the amount of $2,800, which is Exhibit 191, but we previously had testimony from K.Johnson saying she didn't know what the program, how the program worked, or if there were any policies related to it. This is also the same month that she is seeking reimbursement for her garnished wages for a judgment in court. The same month and the same year. Your Honor, with Exhibit 203, we have a check in the amount of $275 where the court received totally contradictory, and what I would argue would be perjury on the record, stating that this was a housing authority vehicle. That answer was provided under my direct examination. It was also provided under Attorney Anderson's direct examination. But when confronted with this invoice, it's a mistake or it wasn't intentional. I would argue, Your Honor, that this invoice encapsulates the heart of this case, that misappropriation and fraud was actively committed by K.Johnson against the housing authority, and the documents speak for themselves. Your Honor, we have Exhibit 265 that clearly shows that Ms. Johnson is spending $599.94 on a phone for her daughter. We have Exhibit 275 in the amount of $637.38 for a phone for her son, Your Honor. And we were provided all kinds of roundabout testimony about how it wasn't actually for them, it was for her. Do we have proof of that? No, but what we have are these documents that, again, speak for themselves. Again, Your Honor, the major threshold question this court must consider in this case, and the evidence that has been presented, is whether Karen Johnson is a credible witness. And unfortunately, she's the only witness that the defense has proffered to the court. This question is monumental since the only evidence Karen Johnson has offered up in her defense is her own testimony. She hasn't provided one document to corroborate anything that she has said, and she has not provided a witness to corroborate anything that she has said. It is her word against the record and the testimony of Rick Peterson and Michael Olo. Karen Johnson has not asked this court to accept one page of documentary evidence as an exhibit on the record because there is no paper that helps her. It all hurts her. Karen Johnson has not asked this court to swear in one witness to testify to provide evidence corroborating her story or supplying information related to her character. This is not only telling, Your Honor, it is critical to this case. This court should be fascinated by the fact Karen Johnson has put up a defense, has only put up the defense of, Dwayne told me it was okay. One of Karen Johnson's defensive theories is that of superior orders, Your Honor, also known as the Nuremberg defense or just following orders. The problem with this defense is that she profited from the conduct. She had an inherent conflict of interest that negates the superior orders defense. Casting blame on a supervisor for her rampant abuses of power and fraudulent action is not an affirmative defense. It would be different, Your Honor, if Karen was ordered to do something that did not benefit herself, like placing a homeless tribal member family in temporary housing without her director's signature, or purchasing space heaters for tenants whose furnace went out. Instead, we have hundreds of payment vouchers where Karen Johnson signed the check request. She signed once the check was created. She co-signed the front, and then she endorsed the back when it was taken to the bank to reimburse her for $450 a night luxury hotel rooms in Chicago with no stated business purpose, for Blackhawks versus Wild games, for mileage from Cumberland to Hayward 10 times in a given month, or for the housing authority to pay her mom's cell phone bill. How do any of these alleged transactions benefit the housing authority? How do any of the alleged transactions benefit tribal members? How do any of the alleged transactions benefit the tribe? I would argue, Your Honor, they don't. All of these checks were misappropriated funds to benefit only one person, and that's Karen Johnson. All of these checks strike that. They were also the result of a fraud carried out by a tribal member against her own tribe. Someone who was entrusted with a fiduciary duty and instead took advantage of it. The defendant knew she had not received those disbursements and that other tribal members were not receiving anywhere close to the same level of disbursements as her. Through the presentation of this evidence, the tribe has established each of the elements of the 18 counts presented in the tribe's complaint. The defendant received and cashed checks directly from the St. Croix Housing Authority while she was a housing authority employee in violation of federal, state, and tribal laws. The formal request for relief that we're asking, Your Honor, is that the tribe requests that the court find the defendant liable for all 8 counts of Wisconsin's civil theft statute, 9 counts of misapplication of funds, and issue a declaratory judgment that because of all of this, the defendant is not eligible to run as a candidate in future tribal elections. Your Honor, we ask that the court issue an order requiring the defendant to pay restitution back to the tribe and the damages, in damages related to the illegal disbursements that she received, $9,853.36 in unauthorized overtime and payroll, $6,359.69 in personal expenses, $31,343.37 in mileage and travel, $35,159.96 in children's sports activities, $19,660.42 in home repairs and upgrades, $8,500 in home equity withdrawals, $2,432.21 in vehicle repair and maintenance. Your Honor, the parties have submitted a stipulation related to her accepting responsibility for 75% of the Verizon wireless payments, absent the phone purchases, and then the entire amount of the Robert Barker fraud, which is $58,918. The tribe also requests that this court order the defendant pay the tribe's attorney's fees in this entire litigation. And Your Honor, thank you to the court for hearing the tribe's case. Thank you.
Give me a second, Attorney Henderson.
I'm sorry, Judge, what did you say?
Give me a second.
I'm patiently waiting.
This is Attorney Anderson's opportunity to present his closing. Do not expect any interruptions. Thank you. Attorney Anderson.
Thank you, Your Honor, Mr. Adams. At the outset, I guess I'd like to make some comments on Mr. Adams indicating that somehow my client had a duty to step forward and say I remembered something different as it related to Coachella. That's just not the case under the rules of civil procedure. Secondly, he made numerous comments concerning we never presented any documents to him. Now, to the best of my knowledge, there was no request for production of documents that was not complied with. And even if it wasn't, the appropriate remedy is to bring a motion to compel seeking a production of those documents. But as to the best of my knowledge, we did in fact comply with whatever discovery was presented to the defendant, and we responded in kind. So I don't know what Mr. Adams was expecting us to do from a defense perspective, frankly, other than for compliance with discovery rules, a defendant is entitled to sit in her hands. Now, I want to state that the court at the outset of these proceedings indicated that the burden of proof in this case is clear, satisfactory, and convincing. And already, I believe, and I'm going to go through the allegations as set forth in the complaint of the tribe. The first of them relates to $9,853.36 of overtime, covering a span of roughly 4 years and 1 week. As was testified to yesterday, I believe by Mr. Peterson, the housing authority was subject to audit on an annual basis. He was not aware of what was done with audits for the years when he was not either in position of tribal authority. But nonetheless, if you talk about evidence, Ms. Johnson is a competent witness to testify as to what took place. She testified that her overtime was in fact performed and her vacation was in fact bought out. Now, was this done in accordance with policies? Frankly, there was a director of this agency hired by the St. Croix tribe to oversee this agency. The vouchers that we've been hearing about all these many days clearly do provide a place for a director's signature. The fact that the director chose not to deal with these vouchers and just let them be processed out is not the fault of K.Johnson. It's a failing of the director to follow his own duties. But I think as far as the everything with the last two, which is the reimbursement of garnished wages on the overtime, is clearly something for which Ms. Johnson was entitled to pay. Should it have been processed differently? Perhaps. But nonetheless, she earned it. She should be paid it. As far as the reimbursement of garnished wages, the documents presented do not show that it was properly docketed within the St. Croix tribe. Those documents are, the documents we were provided with are all circuit court documents. But the testimony from Karen was that she had actually previously paid off that particular judgment, and the tribe made an error in honoring the garnishment. If the tribe chose not to pursue this back through the circuit court, that was the choice of the tribe, not K.Johnson, but certainly he should not be required to pay a judgment twice. Moving on to the $6,359.69 of alleged personal expenses. Yes, Ms. Johnson has testified that her boss, in numerous occasions, either suggested or approved various perks for her, including, now she has said that she was in Hawaii at a conference. That's the only testimony about that that's before the court. The there was no deposition presented that would have asked her about whether she was in a Hawaii conference. An iPhone repair. It was listed as a repair. It also included certain expenses for the purchase of roughly not quite $20 worth of stamps. She testified that it was her iPhone that had a broken screen and needed replacement. Was it extravagant for Karen to be allowed various tickets for sporting events? Probably, but that's the way the director chose to run his agency. Next, there are 3 items totaling $239.72, $226.91, and $80, all related to a golf outing that this agency put on for its employees. And this $550 or so of expenses were for all of the employees of the housing authority for an event put on by their agency. Karen paid this money and excuse me, my phone went off. Karen paid this money and was entitled to reimbursement for that. It's clearly related to the housing authority, as it was an event put on, and let's be realistic, many agencies put on team building type events where their employees see each other not strictly in a work setting, but rather something more casual. And that's what happened here. And Karen, with instructions from her supervisor, went and acquired the necessary items. As it turns to the last item on page 7, and then frankly, it was a Walmart purchase for $175.46. It's spread out on numerous items. A $14.97 answering machine clearly was for office purposes. I can't justify any of the rest of it. Much as I cannot justify $1,000 Blackhawks at Minnesota Wild tickets, other than her supervisor, who had every opportunity to look at any of the purchases she had made at any time and put a halt to it. The supervisor had every authority and every ability to say, I want to see all the vouchers and don't pay them until I sign them. Apparently that supervisor just did not do that as part of his job. Turning to the unauthorized mileage and travel, which is alleged. Karen has testified to what these were for, primarily during her initial adverse examination by Mr. Adams. Many of them are not work-related. She attended some training and received mileage for that. She attended training for HUD, APR, IHP. She's entitled to reimbursement as well as mileage and meals. The ICDBG training. She had many of these that are actually documented as 12/18/2017 Chicago APR, 12/19 Green Bay self-monitoring, likely on the way home from that Chicago training. She acknowledged that the January 19th Wisconsin Rapids trip was college visits for her daughter, and while approved by her supervisor, did not contain a work-related purpose. She attended management training. She attended an economics meeting. There's just numerous of these that are valid. When she attended the June 25, 2018 meeting in Chicago, the September 21 APR, IHP. She can't be specific about the Madison training, but that's what the court can work its way through all of the various allegations against her and make an appropriate determination. The Global Gaming Expo that she attended in Las Vegas is certainly interesting in terms of whether or not it was work-related. I don't think there's any doubt that the gaming conducted by the St. Croix tribe affects all of the agencies. And I don't think it's unreasonable that a supervisor such as Mr. Emery would have some of his staff attend a gaming conference as it affects all of the agencies within the tribe. Next, there's the training that she went to in Oklahoma City, clearly work-related. Apparently one night in a hotel, meals and mileage. She only charged one way for the mileage. Then there are all of the EPIC trainings where she took various seminars for that new program. That adds up to several $1,000s. And again, I'll leave it to the court to determine those things. The last three items in that category, the 3519, she can't recall what that is. The state track meet should not count, and there was not a report due to HUD as far as she recalls. I leave it to the court to separate the wheat from the chaff. We then turn to the $35,159.96, which are clearly child-related sports expenses. K.Johnson has testified that her supervisor encouraged and told her to do it this way. I don't think it's any secret that tribal children participating in extracurricular activities, among them sports, is a positive for the tribe and not unknown among various agencies encouraging that type of participation. That will have to be a decision by the court as to whether or not any or all of that should be approved. Turning to the home repairs and upgrades. Karen lives in a prefab home of the 1990s vintage. She explained why the furnace call was done at her home, that her home is in a project. In fact, it's still, as I understand it, the tribe still maintains records on this home, according to Ms. Lowe. Karen has indicated that the furnishings should not be included in her home repairs and upgrades. She testified that, in fact, the rest of it did, in fact, go into her home, with the exception of she doesn't think one of the sets of cabinets went into her home. She just doesn't recall, as far as that goes, where if that was part of her project or not. She testified that Mr. Michael Jones for the deck, she got a new deck and a new bathroom as a part of the project. She testified as to the need, among other things, that the bathtubs were starting to leak. The other Capital One Menards are explained and did in fact go into her home. That whatever, how that applies to her home, there was no testimony about that. Turning then to the MEPA, the equity withdrawals, by its own terms, on its own face, these were equity withdrawals that Karen had money in equity against her home. She had equity that she could then withdraw for needs. There were no, while there was something on a form, there were no hard and fast rules presented to her at any time as to what she could do. The MEPA account, the equity withdrawals, that is clearly a matter that'll be resolved at such time as her home is transferred to her, that she's had and been in possession of for some 25 plus years. But equity, just like a home equity loan, if you've got equity in your home, you can take it out. And that's what happened here. The other interesting thing is a home equity withdrawal apparently was made to the tune of $2,800 for a court judgment. That being a court judgment that she had to pay off, which is likely the court judgment that resulted in a garnishment. And then she paid it off. She did get reimbursed by the tribe, because she had taken a home equity or an equity line of credit to pay it out and did, and then the tribe also garnished. And at that point, it's between the tribe and the whatever agency of the tribe paid that garnishment and the creditor, which may have been overpaid. But Karen should not suffer because she actually took a home equity loan to pay for that judgment, and it was garnished. Turning to the vehicle repair and maintenance. Again, this runs a period of nearly 5 years. There were, frankly, not all that many auto repairs. Now, Karen's testified she thought mileage was mileage, and she was entitled to the appropriate rate, whether it be 54 or 55, whatever it may have been at the time, for the use of her car. She was not aware of the IRS regulations that would say that money covers everything, including day-to-day maintenance. Now, she did testify that of the repairs, the $228 for the air conditioning fix in Rice Lake was on a tribal vehicle. She believed the windshield replacement was on a tribal vehicle, as well as the tires. The other items clearly were for her 2015 Equinox, with the exception of $35 of windshield wipers. There was no malevolent intent by Karen on these. She was of the belief that she could get the minor maintenance done and have it paid for by the tribe because she used her own vehicle, not knowing that the process of mileage was to include not only the gasoline, but also other items. As Mr. Adams has correctly stated, we have reached an agreement on the Verizon wireless, wherein Karen will be responsible for 75%. I think a dollar amount was included in the stipulation. I don't have that come up on my laptop at this moment. But that stipulation speaks for itself, as to also the stipulation as to Robert Barker. Now, in conclusion, and I realize that this turns the court into an accountant, but in conclusion, Karen's checks were hiding in plain sight. She wrote vouchers, attached whatever documents she had. She wrote a voucher, and if it was for hockey or track and field, she clearly wrote that on there, that it was for hockey tournaments or otherwise. Karen did not in any way try to hide any of what she processed. Again, they were put in the same place as vouchers for vendors or contractors. Had anyone, whether it be during an audit, which concerns me that audits were done, perhaps these matters should have been brought to the attention much sooner. But for some reason or other, whatever audits were done did not pick up on these allegations. The fact that there was a form that did not contain a supervisor's signature in the vast majority of cases, perhaps that would have been noted by someone, realizing that Mr. Emery was the director and that there was nobody below him between him and Karen. And I realize she may have been a little bit inarticulate in trying to explain that, but it's quite clear that that's what the situation was. It was Mr. Emery, and then down to Karen, Natasha, and I've forgotten the other person's name. I believe it was Jody. Again, Karen could have hidden vouchers. She could have hidden copies of the checks. She could have had them made out to other people. None of this was done. Karen was following instructions. She was not committing heinous crimes against humanity. It's harsh at best to bring up the Nuremberg aspect of this, when Karen clearly not only had instructions, she had tacit authority and approval for the things she did at the housing authority. Judge Booley, I thank you for your time and patience throughout this matter. I'm certain that the court's decision, when rendered, will do justice. Thank you.
Attorney Adams, are you going to want to respond?
Just very briefly, Your Honor.
Okay, hold on. All right.
So I will keep it extremely brief, Your Honor. Ignorance of the law is not a defense. Just because you know, or just because you don't know that it's illegal to break into somebody's house and steal something, doesn't mean that you can invoke that as a defense. And the other thing I will say, Your Honor, that I'll leave the court with is, just because Dwayne Emery said that it was okay for K.Johnson to spend the money in the way that she did, in the way that it's alleged, does not make it okay. It doesn't make it all right. Thank you.
Attorney Anderson, do you have a response to that?
No, I believe it's all been argued. Thank you, Your Honor.
Right. Well, my calculations we were scheduled to have a hearing on June 1st at 8:30, starting at 8:30. I'm going to use that time to render my verdict. Unless, of course, something comes up, but that's my plan to do. So hope you guys can be back here at that time and then I'll announce my verdict in open court. All right,
Yes, Your Honor.
June 1st at 8:30.
8:30, yeah.
Thank you.
Okay, so with that, we'll thank the parties for presenting their case and we're getting through this. And what we'll do now is we're going to deliberate for a couple days. And then I will see you guys on June 1st. You guys will hear my verdicts. All right, court's adjourned. Have a good day.
Thank you, Your Honor.
Thank you, Judge.